So one of the things I want to start with is sort of discussing the differences between branding, social media, NIL, and what we call colloquially NIL that really is for pay for play. So there's kind of three buckets that we could put NIL into. First is that social media bucket. The second is what Tim had mentioned before, which are collectives, which are essentially booster groups that support NIL at a particular institution. And then the third bucket that we have is relatively new as of about 9 days ago, which is revenue sharing, which is directly coming from institutions. So this all falls under the broad umbrella of name, image, and likeness. But obviously, the contracts, the payments, the provisions related to them are pretty different depending on what exactly we're talking about. Is it McDonald's showing up and saying, we want one social media post on your Instagram feed? Or is it the University of Florida saying, we want you to come and play football at the University of Florida? Those are two really big, different things. Obviously, the contracts are going to look really different, even if there are licensing components, intellectual property components, and sort of various complex terms. So, how did we get to this revenue sharing part? Is a really long story that started over 10 years ago with a case that was came out of the Ninth Circuit, U.S. Court of Appeals for the Ninth Circuit in California, called O'Bannon. And Ed O'Bannon, some of you may know the name, played college basketball at UCLA way back when in the 90s. He obviously had taken an issue with the fact that his name, image, and likeness was in an EA Sports video game. We had a lot of antitrust litigation since then, all sort of culminating in a case that just settled House v. NCAA and the Power Four slash Power Five conferences. And the result of the settlement of that case being approved is that we have direct revenue sharing for the first time for the essentially the name, image, and likeness being licensed to the university. They can then take that name, image, and likeness. They can put it on signage around the stadium. They can license it to third-party vendors such as Fox or CBS. There is a lot of rights that come with the license that the universities are purchasing. But essentially, in a lot of senses, this is pay for play. The university is saying, you are really valuable to us as an institution. We gain a lot from marketing your athletics ability. We are going to pay you X number of dollars to come to our school. And there's a lot of questions about, on a moving forward basis, what the settlement is essentially going to look like. And so this is only at the Division I level. But we do have it's 319 institutions, I believe the number is, that have opted into the settlement. So everybody but the Ivy League and military academies are a part of this, and they are going to be directly sharing revenue with student athletes going forward, and have already as of June or July 1st. Some payments did go out. So it's different school to school. Obviously, we've been asked the question quite a bit: is what are the institutions doing in terms of breakdown? And we've seen some schools that are saying we're going to meet that full cap. It's 20.5 million for the coming year. Other schools have said we are not going to come anywhere close to that. We're looking to spend $500,000 total. And where does that vary? We've seen a lot of schools that have kind of gone along the settlement lines: 75% going to football, maybe 15 to 20% going to men's basketball, the remainder being doled out between women's basketball and Olympic sports. But again, we've seen this vary school to school. So we've seen some schools, I have some examples here. Ohio State, as an example, is only going to be providing revenue sharing payments to football, men's and women's basketball, and women's volleyball. So the remainder of the sports are not going to be receiving revenue sharing checks. That is only going to be limited to those sports. And this is obviously independent of any name, image, and likeness activities that they can do outside of revenue sharing. They can do the normal social media marketing deals. Obviously, collective NIL still does exist, although we can talk pretty extensively about the new clearinghouse that's associated with that. But that's just an example. Another example I have as a little bit of a contrast: University of North Carolina, Chapel Hill, also football, also men's and women's basketball, but then baseball, and that's it. So it's a little bit different from school to school. And obviously, when we look at the Division I level, there are some schools that do not sponsor football, that may be in a little bit of a different setup. We have seen, as another example, the Big East commissioner, Val Ackerman, has come out and said that she thinks Big East schools are actually going to have a huge advantage because they can put a lot more money towards men's basketball and women's basketball than some of their competitors could that are also funding football teams. The estimates at the Big East level, we're talking in the range of $5 to $12 million per year across all sports, which is below the revenue sharing cap of 20.5 million for this coming year. So again, it does vary institution to institution. And another component of that settlement agreement in the House case is the new roster limits. So we've done away with the headcount sports and the equivalency sports, where athletes are going to be getting a quarter of a scholarship and half of a scholarship. We've done away with that. The new limit is the total number of athletes that can be on a roster. So if we're looking at football, it's 105 scholarships. If we're looking at basketball, 15 scholarships. Again, varies a little bit by sport. And we have seen a lot of schools, particularly at the Power Four, Power Five level, that have come out and said they're actually going to be sponsoring more scholarships than they were able to before under the old rules, where we did have those equivalencies. There was a certain limit that we could have in sports like baseball, volleyball, so on and so forth. So that's sort of in a nutshell what we're looking at with the House case. But I think one of the questions that I do get a lot is what are we practically seeing? And I think when we're looking at the practical on the ground effects of this, athletes are signing contracts with institutions for and oftentimes hundreds of thousands or millions of dollars. We started to see the very first revenue sharing MOUs, memorandums of understanding, in December of last year. So they have been coming up until late June, right before the settlement went into effect on July 1st. And everything that we're seeing so far is everything from really complex commercial agreements all the way through to short kind of 1 and 2 page documents that are, not all that sophisticated. And really everything in between. So each school is taking a little bit of a different approach to this. I think, from the legal perspective, I do always say it's easy to say from the lawyer's chair, it's really important that you understand what's in that agreement, what you're agreeing to, what rights are you giving up. And CC had mentioned this a little bit before. It's no different in a social media agreement. One, obviously, you want to make sure you're getting paid what you're worth, but also in exchange for whatever you're being paid, you are giving something up, right? You're either giving them the right to use your name, image, and likeness, the right to buy some essentially ad space on your social media feed. You are giving something away. And there are terms and conditions associated with that. So it's really important to understand what exactly are we giving away here? What are the long-term IP rights? Are they able to use this in perpetuity? I've been saying this for over 4 years. The biggest threat to any college athlete, any high school athlete, is when you're a senior in high school, freshman in college, you give away, in perpetuity, the rights to your name, image, and likeness in exchange for $500, in exchange for a free sweatshirt. Believe it or not, it has happened. It is out there. And then what happens when you play your way into being a first round pick? You're a professional athlete now. Somebody says, "Hey, wait, remember that $500 we paid you, and here's the contract." Well, you're going to have a problem. So you want to make sure you're understanding what is in the nature of those agreements, making sure that it's fair, making sure you're not giving up more than you should in exchange for whatever it is that you're being paid. And again, going back to the real practical implications for college athletes, the settlement is pretty paramount. I think, broadly speaking, it is a net win for college athletes to be able to earn a larger share of the pie than they previously were able to. But it doesn't come without pitfalls. We can talk about there's a new reporting system. We talked about that clearinghouse. So it's important for athletes to understand what NIL deals are they going to have to report to the new NIL Go system. I think there's an interesting question of balance on collective NIL versus revenue sharing NIL. If you're being recruited to a particular institution and they're promising you X number of dollars, okay, well, where are those dollars coming from? Is it revenue sharing 100%? Is it going to be 50% revenue sharing, 50% collective? Is it 100% collective? I think there's some risk associated with doing it sort of either of those ways. But it's important to understand where is the money coming from. If they're promising it, let's see it in writing. Let's sign a contract. Make sure we understand what everybody's agreeing to here. And I think the other thing that really is kind of lost in all of this is, well, what are the long-term implications? For the first time, we have institutions that are paying athletes, in a lot of cases, a large sum of money. But what are they getting in exchange for that? What are the athletes now going to be on the hook for? There any long-term IP rights that are being granted to the university? What are the termination clauses? If the athlete transfers, do they owe that money back to the institution? I think there's some really important stuff that athletes need to be aware of and understand what are we agreeing to here. So certainly could talk pretty extensively about NIL and the legal implications to ad nauseum. But certainly I always say understand what you're agreeing to and how that broadly affects, like Cece was mentioning, you were a business, right? As an athlete, you now own intellectual property. You probably have tax write-offs, right? These are all things that we should be cognizant of just to make sure we're best protected going forward.